right. The special meeting of the Board of Education for September 10th, 2024 is called to order. All items being considered this evening are posted on the PPS website under the Board and Meetings tab. This meeting is being streamed live on PPS TV Services website and on Channel 28 and will be replayed throughout the next 2 weeks. Please check the district website for replay times. Good evening and welcome. Tonight we're being asked to consider the dismissal of a contract educator, Mr. Nathaniel Williams. Employee discipline matters are confidential under state law unless the employee requests the matter to be considered publicly, which Mr. Williams has requested. In addition, Mr. Williams was entitled to the pre-termination hearing under PPS policy. That nearly 2-hour hearing involved hundreds of documents, was held on August 29th before a hearings officer, and the board has received a recording of that hearing and supporting documents. Mr. Williams and PPS have agreed that the recording of the hearing and the evidence discussed will be available to the public. After considering the evidence, including over 1,000 pages of documents, the hearing officer found that the district established that Mr. Williams' actions constitute insubordination, neglect of duty, immorality, physical or mental incapacity, and inadequate performance. All statutory grounds for dismissal per ORS 342.865. Her findings and conclusions, the documents offered by both sides, and the hearing itself are all before the board for consideration. Before we move to a vote, Mr. Williams has requested to address the board, followed by 3 public commenters related to the board vote. Let's begin by getting the motion on the table. Do I have a motion and a second to adopt Resolution 6961, dismissal of a contract teacher?
Motion.
Second.
We have Director Hollins moved, Director Scott seconds. Mr. Williams, would you or your counsel like to provide your comments at this time? Okay, you will have 10 minutes. Thank you.
Point of clarity, do we get to ask questions after they're done, or?
That's a good question.
There's more discussion afterwards, and I think you can ask questions if you have them.
Okay, thank you.
Thank you. You have 10 minutes. You may go ahead when you're ready.
Thank you. Good evening, everyone. I'm here to express my profound concerns about the district's handling of my situation, particularly regarding the false statements made against me and the emotional and psychological damage that has resulted. While the district expects teachers to implement restorative practices in the classroom, my experiences highlights troubling disconnect between these ideals and the actions taken by the administration. On August 25th, 2023, following the sharing of restorative practices with my colleagues, I was summoned to the office and subjected to questioning by Sarah Fitch. She informed me that I was at risk of losing my job if I didn't take a drug test. During our discussion, I told her I had been prescribed 2 medications and that I was now only taking 1. She then asked if I could provide her with the prescription. I said yes and showed her my prescription. However, when she requested to take notes, I did allow her to take the notes, but she wanted to take photos, and I declined for her to take photos. But after further discussion, I asked her why I had to take a drug test, to which she responded, because we don't want people in front of our kids who do drugs. Despite any lack of reasonable suspicion that I was under the influence of illegal drugs, I have been falsely accused of being under the influence of meth. I did not take meth. I took Adderall, a medication that was prescribed for me by my doctor for my ADHD. Adderall is very similar to meth in its chemistry, but it also has the same intoxicating effects. Does not have the same intoxicating effects. The accusations that I use illegal drugs is not only untrue, but also deeply damaging to my reputation and my mental well-being. The decision to place me on leave and now to terminate me has compounded the emotional and psychological damage I have experienced throughout this entire process. The district's actions have felt more like a witch hunt than a fair investigation. Instead of prioritizing the best interest of students and supporting its teachers, the administration has resorted to punitive measures that undermines the very principles it professes to uphold. It is crucial to understand that the damage caused by these actions will take significant time and effort to undo. The investigation has lacked integrity, included false
I'm going to pick up where Mr. Williams left off. Included false statements, misleading information that appears to have been used to persuade your decision today. I urge the district to reflect on its commitment to supporting educators and consider the implications of its actions on my mental health and professional standing. I am before you today to ask you for one thing. Do not fire me. Do not fire me because it will harm me, it will harm students, it will harm the Fabian community and the entire district. And after you look at the actual evidence and see the reality of this situation, I hope you agree. I did not use meth, but I am a black man in Portland, and I had the courage to get medical help for my own mental health needs. And then I had the very bad luck to be prescribed medication that is chemically similar to meth and that can't be distinguished from meth on a drug test. I did everything the district asked to prove my innocence. I presented proof of my medication so many times, the district ignored it all. I hired a toxicologist to explain the chemistry. The district ignored it. I presented witness statements of people who said I was not intoxicated. The district ignored it. Everything I said and did was ignored because it didn't fit with the district's initial assumption that I was a drug user. That assumption is wrong. Look at the facts and believe me. Believe in what I have done for our students. Believe in what others say about me, what students say. Because I know the truth about what happened, and I think you know the truth too. And I am confident that you have the courage to act on it. Thank you for your time and your patience. I would like to make some comments as well. This is on behalf of Portland Association of Teachers and Mr. Williams. In our view, this case is about stereotypes and assumptions, and how once they take hold, no amount of evidence can defeat them, and how sadly, PPS's Human Resources Department has stubbornly refused to consider the actual facts in this case. That Mr. Williams is a black man who is brave. He is brave to take steps to treat his mental health needs, his ADHD. He took his prescribed Adderall as required by his doctor. He came to work, performed his job without any signs of intoxication, and now he stands falsely accused of being a meth user, a liar, and an unsafe teacher. And this is all fiction. And it's a fiction that's been repeated, reinforced, and embellished, first by PPS HR staff Sarah Fitch, and then by others who relied on her original work. And it's repeated now so often that PPS cannot see it for what it is. And in spite of this campaign, this smear campaign, Mr. Williams has remained calm and put his faith in the facts and his trust that the district would eventually come to its senses. He has disproved the allegations again and again using documents, logic, calling out racism and disability discrimination, all of which led us to this point. But once PPS made up its mind, it appeared that nothing could stop it, not even the actual facts. And here I want to show you the fiction and the facts behind it. So let's talk about the actual facts. Mr. Williams did not use methamphetamines. He has ADHD. He was prescribed by his doctor 2 separate medications to treat that condition. One is Wellbutrin and the other one is Adderall. Both Wellbutrin and Adderall have been shown to demonstrate false positives on tests for methamphetamine. But Mr. Williams did not know that. In the summer of 2023, he was in a child custody dispute. He was required to take a drug test by the court. And because he was ashamed of his mental health diagnosis, he didn't disclose that he was taking medication for ADHD when he went in to take that drug test. He didn't think it was necessary to disclose it. He also didn't have a lawyer to help him in that case. And like so many people interacting with the legal system without help, he was not able to explain his situation clearly to the court when the drug test came back positive. And the court incorrectly concluded that he was using drugs. And he's in the process of appealing that decision. But now let's get to the fictions that PPS has adopted and the facts behind them. So the first fiction is that PPS now claims on August 24th, the day before the test in question, they claim that he told his coworker Damon Miller that he had, quote, screwed up recently and failed a drug test after attending a festival in Astoria. This is a false description of the conversation between Mr. Williams and Mr. Miller. It derives from a 2-line note that's undated and unattributed in the HR file, but we know that it was written by Ms. Fitch. And you will hear from Mr. Williams, perhaps even Mr. Miller, and others, that that's not what Mr. Williams said. And how do we know this? Because there's an email exchange after this point between Ms. Fitch and Carmen Williams, the principal at Mr. Williams' school. And Ms. Fitch attempts to verify that her note is accurate. And Principal Williams says it is not accurate. She says, quote, and this is on August 29th, I don't believe the screwed up piece tied directly to the test, but to the overall situation. In fact, what Mr. Williams had told Damon Miller was that he had screwed up by not disclosing his ADHD medication at the time of the test. But did Ms. Fitch correct her statement in the HR file? No, she did not. And then PPS used that 2-line statement as one of the bases for its allegations against Mr. Williams.
Sorry, Joe, just one more minute.
Well, I appreciate your time limit, but that is a matter of dispute between the union and the district. We have not agreed to a 10-minute limitation. It violates the party's past practice and the policy. So if you insist on adhering to that restriction, I will honor that request, but it will be subject to legal challenge because this is not what we've agreed to, and it also would be an unfair labor practice. We filed an unfair labor practice before on this very issue, which is the parties have reserved their positions on it. So I would request that you allow us to continue. There is a lot of information that you should hear.
Mr. Barish, we're aware of the union's position. Chair Wong, it's your decision how much time to give him. We've discussed at length the 10-minute restriction as a general practice, and we disagree with the assertions about past practice. At the end of the day, this is the board's meeting, and you get to decide how much time to extend to Mr. Barish.
How much more time do you think you need?
At least 10 more minutes.
Can we give you 4 more minutes?
All right, I'll continue, and it's still subject to challenge. So what's the next fiction? That PPS claims that on August 25th, Mr. Williams was intoxicated at Fabian Elementary School. What are the facts, actually? He had taken his prescribed Adderall and was not intoxicated. How do we know that that's factual? Because John McGee, another teacher, indicated that Mr. Williams was calm, relaxed, and professional and not intoxicated. Because Damon Miller, another colleague of Mr. Williams, said that he had never seen Mr. Williams intoxicated and that he actually Mr. Williams gave a presentation to staff that day about restorative strategies and that Mr. Williams was professional and sober. We even know it from Principal Williams, Carmen Williams, who noted in her statements to HR that on that Friday, the 25th, Mr. Williams was acting professionally and that he had mentioned that he had a recent change in his medications, which is exactly what happened. And we also know that there's no evidence, zero evidence from any of the scientific experts or any of the testimony at the pre-termination hearing that Mr. Williams was intoxicated on that day. So that's false. And that is one of the allegations that the district relies on in its notice for termination. What's another fiction? PPS claims on August 25th that Mr. Williams showed Ms. Fitch a pill bottle with a torn label, with a date missing, and refused to provide his prescription information. This is all meant to paint him as deceptive. The facts? He showed his current Adderall bottle with an intact label, showing that it was current. She copied down the information. And he just asked that she not take a picture of it because it had his private medical information. What else? Fiction. PPS claims that he refused to share his prescription information with PPS after August 25th. There's no less than 5 different times when he shared that information. First, on September 13th, he got his copies of his prescription. On September 18th, he sent those printouts to the medical review officer requested to receive that information by the district. On September 19th, he sent additional paperwork. On the 20th, Mr. Nguyen for PAT confirmed that he had complied with PPS request and submitted his medication. On September 26th, he resubmitted his information to the medical review office. On October 3rd, Ms. Fitch said they still didn't have his information. Well, on October 4th, he resubmitted it again, both pictures of the bottle and the prescriptions. And on October 5th, the medical review office confirmed receipt of those. Yet, after all that, the notice of termination still claims that Mr. Williams failed to provide his prescription information to PPS. How can you look at those facts, which are undisputed, and say that the district is acting in good faith here? What else? Fiction. PPS claims that the results from Mr. Williams' drug tests on the 25th proved he used illicit methamphetamines. There's no dispute that that's what the lab result was initially, but you know what? Adderall is a therapeutic form of amphetamines. And reputable labs, like OHSU, for example, include a disclaimer on this test that says, quote, "This test will produce results for urine specimens collected from patients, will produce positive results for urine specimens collected from patients who are administered Adderall." This is science. This is OHSU. If they had received the test...
Did you finish up?
Yes. I have much more, but I will tell you that the 4 grounds for termination, the 4 statutory grounds relied on by the hearings officer, none of them are valid. Insubordination. Mr. Williams, to be fired for insubordination, he would have to intentionally defy district directives. He didn't do that. There's no defiance. He did everything that they asked. Neglect of duty. In the case Crouch versus Springfield, this is a Fair Dismissal Appeals Board case, 2018, that board found that a teacher who had used cocaine and then drove and got a DUI did not neglect duty.
Oh, I'm sorry, can you please finish up?
Yes. Immorality. Again, in that same case, the board found no grounds for immorality when someone admitted to using off-duty or illegal drugs off-duty and got in a car and drove. Still no immorality. And finally, inadequate performance. It's not even a relevant charge. The Fair Dismissal Appeals Board has cited on many times that that only is relevant for a violation or a failure in the technical aspects of teaching. It's a very specific charge for someone who's on a plan of assistance who has poor evaluations. We've cited these cases over and over and over, and yet the district moves forward. None of these grounds are valid. So you should think very carefully, please, about what is the fact and what is the fiction here. Mr. Williams has already issued a tort claims notice against the district. We have been exceedingly clear about the problems with this case over and over and over again, and it's your chance to fix this. Thank you.
Thank you. Ms. Brashaw, is there any public comment?
I have one person signed up for public comment.
Person? All right.
Damon Miller.
Okay, thank you.
Yes, Damon Miller.
Okay, thanks for coming. Before we begin, I just want to review some guidelines for public comment. the board thanks you for taking the time to attend this meeting and provide your comments. Please make sure that when you begin your comments that you clearly state your name and spell your last name. You'll have 3 minutes and 30 seconds to speak. You'll hear a sound after 3 minutes in which you have 30 seconds to end your comment. Thank you.
Hello, I'd like to begin. My name is Damon Miller. I'm the restorative lead for 5EN K-8. I've been there it's my 7th year coming in. I've known Mr. Williams for 21 years. I met him as I was an associate director for the Police Activities League, PAL, a local nonprofit in the city that was sponsored by the city and police. And him and I, we ran a sports league for football, mentoring, and coaching for over 3,500 kids every year. So this is under city and Portland Police best practices. Mr. Williams was considered a pillar of the North community. He was one of the only coaches that would sit kids that didn't academically meet his standards. I want to talk about the situation at hand. Let's look at our bias on how we look at black men and professionals. This is a case right here where things were charged and going too fast. And our basic pepper teaches us to slow down. Slow down when we're looking at a person like this who has given up nothing but his time and effort to the community, and now he teaches, which is his passion. The things that were said about me, I'd like to say that I did not say them. I'd like to say that the time frame does not work. I'd also like to say that the things that were said about me, that I said, I would have no way of knowing because I didn't speak to Mr. Williams until August 22nd. On August 24th, or the day of the training that his lawyer just spoke of, we had a conversation about how we wanted to take the school over culturally, that he was ready, and he was walked off shortly after giving a presentation. I've never known Mr. Williams in my 21 years of working with him, 16 where I was his director, for him to ever be under the influence, or I've never seen him use drugs. This is something that as easily could be said about a black man, a black professional. I want to point out race because I'm taught by PPS to look at things in a racial perspective. Let's take this black man's perspective and his experience and mine watching it as a person who works at 5EN for 7 years. I've seen, and now I'm a restorative lead on a success advocate. I come to you as an advocate and a restorative person. I've seen my colleagues be given grace. I've seen my colleagues be given a restorative avenue. I've seen my colleagues have union representation that wrapped around them, not excluded them. I'd like to also say that the work that we do, where we put ourselves here for PPS, the skills that we have, is undeserving of this man. I also come to you non-represented. I'm an at-will employee for PPS. That is and should tell you about this place pays my bills. It's my profession of 30 years. It's my passion. And I'm here standing next to him on something that I feel is unfair.
Great, thank you. Okay. The board will now vote on Resolution 6961, dismissal of a contract educator. Is there any board discussion?
Okay, when I read all this first, I had no idea what color you were, by the way, until I came to the part that said you were saying that you thought it was based on color and why you were going against it. And it seemed to me in reading it that it started because of a court decision that between you and your wife, right? That there was some sort of a decision that you could not see your child. And then somehow they said you might have taken drugs, and that's when they talked to you at the school and asked for you to bring the prescriptions. And according to all the papers, you didn't bring the prescriptions. And then, of course, you're saying they did bring the prescriptions. So how are we, I mean, we've got didn't. And it's just very difficult to know who to believe. And also a lot of the information about the Adderall and the and what was the other drug? The one that didn't show it.
Wellbutrin.
Yeah. It seemed like they decided that the amounts that you had were more than you would get in the Adderall, that you would have to get it from somewhere else. And I know people's blood chemistry is different, so that's awfully hard to know what to do with as well. We also had in the information complaints about interactions with students. And what else?
Respectfully, that's not the
Anyway.
allegation before the board.
Well, it was, yeah, but it was before the board as to fitness for teaching. It was all included, at least we had pages and pages and pages of information.
Right. True, I'm not disputing that,
Yeah.
but if you look at the 20-day notice, which sets out the facts that are relied on, teaching issues are not among them.
So we only look at the drug issue.
Correct.
And we also were told that you were given, you could keep teaching as long as you would be willing to be tested for drugs every, I don't know, 3 months, something like that.
Okay.
And you turned that down.
I need to address this because these are settlement discussions. They're privileged, but counsel for the district has decided that to breach that confidentiality and that privilege. The reason why Mr. Williams could not accept that is because he takes Adderall. And Adderall, the science shows, has small but significant impurities in it when it's created in the pharmaceutical process. And those show up as methamphetamine in a drug test. That's what the scientific research shows. So if he were to take the test today, it would come out the same way. So that's why he couldn't agree to those conditions, because it would be a setup for failure. If he could stop taking Adderall for his neurodiversity, he would, and he would gladly take the test, but he cannot, and therefore he cannot agree to that. So we offered a compromise, which was we would send the pill that from the batch that he took to the lab, and they could do that very test on it, and the district refused. I don't think this is a relevant conversation, but since you brought it up, I'm happy to have it.
I just want to clarify. The settlement discussions are privileged when they're in the midst of litigation. We are not. And so they are not privileged settlement discussions.
All I'm saying is what we're going on is what we read. That's all we had.
Correct.
So-
And-
Right. So I appreciate Director Sullivan's questions because there is a lot to look at here, but this is why I tried to go through the fact and the fiction. For example, good point you raised. Did he or did he not provide his prescription information to the district and the medical review officer? You have the documents. I can give you exhibit by exhibit to show you the 5 different times he provided those. There is no denying that he gave them, and how the district could assert otherwise, it is mind-blowing.
I have a question. Since we're going down that road. So, full disclosure, I have a trucking school and a trucking company. We deal with DOT trainings all the time. We deal with USDTL, which is the United States Drug Testing Laboratories. And so,
I don't think people can hear you, Director
sorry.
Hollins.
yeah, so this is, I know a little bit about this. By no means am I expert, but when this came up, I wanted to dive a little bit more into it. So I have a couple questions. One, I know there was a case, a family case, court case, and this came up. And going by the evidence that you provided, you talked about not providing that then, and as with the family court case. When it came up with the school district at the testing place, I know when we send our folks to the court, they always ask if you have any medication, and what those medications are then before you get ready to take your test. I didn't see anywhere where you provided that at the time of testing.
The day I spoke with Sarah, I provided that information to her. I had my,
Well, no, hold on, no. I'm talking about at the testing site.
they didn't ask me to bring it to the testing site.
So when you went to the testing site, they didn't ask if you were taking any medication?
They did, and I told them what I had been taking. When I went to go take the test that day for PPS, I told them that day what I was taking. I also told Sarah.
Okay, and So this is kind of where I'm kind of having a discrepancy at, because usually when I read the documentation and I read the 700 pages from district, I read the 400 some pages from you guys, it didn't look like you gave the testing facility your prescription the day of testing, because they end up going back for a retest, and they usually only do that when they know of a medication so they can retest it.
Yeah, no, they didn't ask me when I was at the lab. They did not ask me for it. So from what I recall, they didn't ask me for it because I had it with me because I showed it to Sarah. So it was in my presence. So they didn't ask me for it.
And so this is just a question. So when you did it at the court for the family piece, and then you came back and was like, hey, it came out wrong, did you think you should have gave them that because of what happened at the beginning?
Well, because of HIPAA, right? I didn't understand what the legalities was for that, so I didn't know what I should share with the courts and whatnot at the time. And so once the results came back, I emailed the judge. I sent her all my information, and she said the only thing she was accepting at that time were the results from my UA. That was it. So again, I didn't have an attorney, so I guess the record was, she closed the record at the time. All she was waiting for was for the results of my UA.
Another question. So when on ours, it shows from the district standpoint, it shows that you went voluntarily, and you stated that it wasn't voluntarily, and it states that your union rep was there.
No, I didn't have so it was a building rep who was
A building rep for the union, though, right?
Yeah, but he was fairly it was like a deer in headlights almost, but it was just somebody that I knew that I felt like comfortable with going in there with. But when I walked in, Sarah did not make it seem anything was voluntarily. She told me my job was at risk. And then I doubled down and asked her again, why did I have to take the UA? And she said, because we didn't want people in front of our students who do drugs. So from there, I never knew it was voluntarily at all. For me, it just felt like from the moment I walked in that room that I was already being accused of it and I had to do it, so.
And your union rep didn't state if you had to or not had to?
He didn't know anything. He just sat there and just took notes the whole time.
He's a teacher at this school. He's not a professional union rep.
Although he has been appointed as the building rep for PAT.
He, at the
Um,
time,
at the
he wasn't
time,
the
and
building,
he
he wasn't the building rep. No, he was not.
There continues to be this narrative that Ms. Fitch ordered him to take the UA. She did not. There's also this continued narrative that Ms. Fitch is lying throughout this and has set this up. That is not accurate. Ms. Fitch met with him to discuss the concerns that were raised after the district received the custody order, which prevented him from having unsupervised contact with his own child. That is why she went to the school that day.
Are there any more questions?
I just have one, and this is for the attorney or whoever. So how do you argue against the isomer or the isomer-based test? So usually they do an isomer-based test. And once again, I'm not a expert. We've gone through this a lot with truck drivers. But so how do you address the isomer-based test, where the isomer-based test is usually one of the tests that they do when they recalculate the test to where they show lab grade ingredients versus basically non-grade ingredients.
So there's three different things there. The first thing, the main point from the toxicology is that the levels of the test, they were 4 times higher on methamphetamine than they were on amphetamine. So it was like about 2,000 nanograms per milliliter on amphetamine and about 500 for methamphetamine. So 4 times as much amphetamine. Now, Adderall is amphetamine. That's basically, it's a medical form of amphetamine. And so what the toxicologist said is, and he's had personal experience as a toxicologist at a drug treatment facility where people are given Adderall in a controlled situation. He says that is exactly the ratio that you will see when someone is taking Adderall. If they're taking street meth, it's the reverse. You will have way more street meth or methamphetamine in the test than amphetamine. And that fact has never been addressed by the district's toxicologist. And he's the only one of the two who's actually dealt with people who are given Adderall in a controlled environment. He was also happened to be the head toxicologist of the Oregon State Police lab. In any case, then there's the issue of the isomer test. And if you look at the underlying science, the testing, the ratio that he had was within those grounds. The other thing is, the toxicologist pointed out that the lab's isomer test was problematic because they had carryover bias in the testing, which basically they run a sample and then they run a blank sample. And if the second sample has any results, then it's carryover from the first sample. And that's exactly what the data showed, and he testified about that. Now, I know there's a lot of dispute between the toxicologists, and that's unfortunate because, you're not scientists, and I'm not a scientist. But you have two respected toxicologists, one of whom has actually worked with people and has decades of experience providing or doing tests on people who've had Adderall prescribed in a controlled environment, meaning they cannot take meth because they're in an inpatient facility. And he says this is exactly the profile you see when someone took Adderall. And I will tell you that he testified this should be an easy case. If this case went to court, and he's testified in court hundreds of times, this case would never make it to a jury because this is a known problem with Adderall showing up as a positive. It's so well known that OHSU puts it on their website that says positive test expected on this from Adderall.
I guess I have a question too, because I'm confused. Am I up for termination because there was meth in my system or was under the influence? Because what I was told was in this paperwork, that was under the influence on the job with kids and around staff. And so then it's being retracted, and all we keep talking about is what was in my system. Well, I hadn't used street meth. And so my levels, again, the lab levels and my levels were pretty much the same. And so I'm confused myself as to what am I up for termination for?
The use of an illicit substance while working, which violates both federal and state law.
So what does while working mean?
While you're on the job, on the day that you were at the school, and the same day that you took a UA, the tested positive for meth, which means that methamphetamine was in your system. There is no argument that you also had Adderall in your system. That's the positive for the amphetamine found. But the medical review officer, the Quest Labs, and the experts all agree that this was the result of having the D-isomer in your system, was a result of having street drugs in your system.
They do not agree. I'm sorry, they do not agree. And as we explained, I can show you the scientific paper that says it was a lab from Kentucky. They took an Adderall pill, they dissolved it, and they tested it, and they found amphetamine and methamphetamine in the actual pill. That's what I'm talking about. It's impure, and that's why you get a predominance of amphetamine and a little bit of methamphetamine from taking the same Adderall pill that's prescribed. I understand what it sounds like we're at loggerheads, and it's been extremely frustrating because the more we try and explain, the deeper we go, the more we try and disprove, the more rigid the district gets. And I think we need to take a step back from the edge here before something
So I just have a
permanent
question.
happens.
Yeah, it's not even a question. Yeah, and I'll be honest, your explanations aren't persuasive to me, to be really clear. They might have found meth in the Adderall, but not at the levels that were found in your client's system. I'm just going to make a quick statement. I don't need you to agree or disagree with me. I want to be really clear and take that step back and talk about what we're talking about here. We have a teacher who has a court order prohibiting unsupervised visits with his own child, to start with. We have multiple parent reports of concerns with this teacher in the classroom. We have a positive meth test result. I have learned more about D isomers and L isomers than I ever thought I would, understanding sort of how Adderall does, its thing. I've watched the entire hearing. I've watched both of these of the toxicologists talk, but, and give their explanation. The reality is there was methamphetamine in your system at a detectable level in the test on the day you were tested. And finally, we have a hearings officer who heard both arguments of both sides, reviewed all the evidence, and upheld the district decision for termination. One of our jobs job's probably our main job. We have a lot, but one of our main jobs as a board is to keep our children safe. And I cannot look at families in this district and suggest that we should put those kids in your classroom. And so I'm just letting you know that after reviewing everything, I'll be supporting termination tonight based on those reasons.
I just want to respond to that a little bit, push back on that. I hear what you're saying. I understand the court order stuff, but even at the same time, the district still was willing to make arrangements or concessions to bring them back to work. So I don't want to make it seem like because of the court order, because we don't know the conditions, we don't know all the variables that goes in family court and court orders. But I guess my thought is if the district, even with all the information present, was still willing to figure out how to work with him to keep him on the job, it wasn't as dire as I portrayed it you're making it at this point. That's just my
Yeah,
opinion.
I will just add, Director Hollins, I again, separate from this hearing, I have some concerns with those arrangements that were offered during the course, but again, that's an operational decision by the superintendent of the team.
Gotcha.
If I can make one more comment, please. The reason why I was punished because I didn't reveal my information about my prescription. So it wasn't because I'm a drug addict or a meth addict. It's because they said I lied and told them that I wasn't taking anything when I was. And so that's what my punishment was. DHS got involved. They didn't even come out and investigate because they said that they're not going to come out and investigate because of parents using drugs. I would have to be negligent in order for them to come out, meaning I would have to have been high, driving with my kid in the car, something of that nature. So the reason why the judge did that was because she wanted to punish me because she figured I was lying. Well, in essence, I didn't tell them, but I didn't know what to tell them as far as my HIPAA, because I didn't want them to know what my medical information was, because they want to dive deep back into the history of it, and I didn't want them to know, and so I didn't know how to object to that, and that's where we land. I've never been a negligent father, ever. And I have a statement, if you're questioning, can I read this last piece from?
We need to
okay.
move on, I'm sorry. Are there any other questions? on the board?
Yeah, I just had, if the district would let you, they said you could come back and be tested. It seems like if you took Wellbutrin, it should not test for methamphetamines. So would you be willing to change your drug to Wellbutrin?
Wellbutrin had a side effect, which I went to Dr. Williams with last year around, I want to say, around March. I went to Dr. Williams. It made me extremely drowsy at the onset, where like I couldn't stay awake almost. And so my doctor, we talked about that, and then we switched to Adderall because of the effects of the Wellbutrin. And plus Wellbutrin, it did not take I didn't feel its effects of what I needed from it until later on in the evening. And so then I found it was really hard for me to go to sleep at night too as well.
I mean, this just points out the problem. Mr. Williams is trying to treat his neurodiversity, his mental health condition, and what we're having is a medical discussion where I understand, Director Sullivan, why you would ask this. I asked the same thing. But he would have to give up his treatment in order to come to work? That's like telling me that I can't take my, autoimmune medication if I want to keep my job as an attorney. This is improper, and it's very dangerous.
Thank you for your comments. All right, we will be voting right now. So, again, this is for Resolution 6961. All in favor, please indicate by saying yes.
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 All opposed, please indicate by saying no.
No.
Are there any abstentions?
Yes.
All right, Resolution 6961 is approved by a vote of 4 to 1 with 1 abstention. This meeting is adjourned. Thank you.